What is up, everybody? We're back with part 6 of me going over Kathleen Zellner's newest filing on behalf of Steven Avery in an attempt to get him an evidentiary hearing. And we're going to pick right up where we left off. All of the other videos, the first 5, are linked in the description below if you want to go back and check them out. If the defense theory is that a third party framed the defendant, the defense might show opportunity by demonstrating the third party's access to the items supposedly used in the frame-up. As stated previously, Bobby Dassey had access to all the forensic evidence and therefore had the opportunity to frame Steven Avery. Moreover, the defendant need not establish the guilt of the third party to the level that would be necessary to sustain a conviction to introduce third-party perpetrator evidence. To support the introduction of such evidence, there must be a legitimate tendency that the third-party person could have committed the crime. This court cannot determine the new evidence regarding Bobby Dassey being in possession of Teresa Halbach's car and moving it into the Avery salvage yard in the middle of the night without holding an evidentiary hearing to determine the credibility of the new eyewitnesses. Speaking of Thomas Sawinski. No matter what diversions the state attempts to raise in its arguments, the issue cannot be resolved without an evidentiary hearing. The state's connection argument. This court must determine first whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. The state, rather than accepting Steven Avery's material facts as true, is attempting to dispute those facts with speculative theories unsupported by the record. By disputing rather than accepting Steven Avery's facts as true, the state is conceding that Steven Avery is entitled to an evidentiary hearing to resolve those disputes. As an example, the state concedes that the necessity of an evidentiary hearing in its footnote 8 by attempting to claim that Thomas Sawinski's admissions have drastically changed. The state is attempting to perform its own credibility analysis of Thomas Sawinski, which is totally improper at the pleading stage, where all allegations must be taken as true. Thomas Sawinski's advertments that he saw Bobby Dassey pushing a RAV4 on November 5th, several days after Teresa Halbach's murder, do not provide a direct connection between Bobby Dassey and the perpetration of the murder. However, the corroborated evidence that Thomas Sawinski does provide precisely establishes the direct connection between Bobby Dassey and Teresa Halbach's murder required by Denny. The state contends that the most generous exhibits that Avery has submitted could establish Bobby Dassey was involved in the moving of the RAV4 to the location where it was eventually found. The state speculates that the reason for Bobby Dassey moving the RAV4 was to cover up the crime committed by Steven Avery. The state's theory is totally nonsensical because Bobby was the primary witness who testified against Steven Avery. He was not trying to help Steven Avery. He was trying to frame him. The discovery of the RAV4 on the Avery salvage yard led to all the forensic evidence used to convict Mr. Avery. If Bobby Dassey was an accomplice, he was the worst accomplice. If Bobby Dassey was an accomplice, he was the worst accomplice ever in a murder scene. Wow. He made such a better star witness for the prosecution, helping to convict Steven Avery while saving himself. The Sawinski evidence provides the direct connection that Bobby Dassey being witnessed in possession of Teresa Halbach's vehicle to Bobby Dassey probably having committed the murder of Teresa Halbach and planning the evidence to frame Steven Avery. The state claims it provides no link at all between Bobby Dassey and the perpetration of the actual killing. It also does nothing to establish that Steven Avery was not the killer, even if believed. All Thomas Sawinski's evidence would show is that perhaps Bobby Dassey was involved in trying to cover up Avery's crime. The new evidence provided by Steven Avery is not cumulative of evidence presented at Steven Avery's trial. None of the evidence provided by Thomas Sawinski directly connecting Bobby Dassey to the actual murder of Teresa Halbach and the opportunity to plant the forensic evidence to frame Steven Avery was known during any prior proceedings in the case. Thomas Sawinski's evidence is newly discovered, unavailable, and not discoverable through reasonable diligence at the time at the time of Steven Avery's June 2017 motion. Thomas Sawinski's existence and information was not known or discoverable by current counsel until Thomas Sawinski contacted counsel on April 11th, 2021. Additionally, the state overlooks the fact that the possession of the evidence used to frame the defendant also qualifies as making someone a third-party Denny suspect. The state waived the procedural bar. Now, they're talking about ESCALONA-NARANJO. The appellate court specifically directed Steven Avery to file this motion pertaining to the new evidence from Thomas Sawinski and specifically stated that the evidence needed to survive any challenge. But the state has waived that case I just spelled out challenge by not raising it. Therefore, the state has conceded that case again is not a bar to Steven Avery's new motion. Mr. Avery has provided a sufficient reason for overcoming that case bar in his third motion for post-conviction relief. Mr. Avery is entitled to an evidentiary hearing on his newly discovered claim. Defendants must meet a 5-part test to obtain a new trial based on newly discovered evidence. Steven Avery has pled facts that would sufficiently establish the 3 prongs of Denny, and Steven Avery's allegations that Bobby Dassey was the perpetrator would be admissible in trial. There is a reasonable probability of a different result at a new trial. The state argues that if Steven Avery presented newly discovered evidence at least satisfying the first 4 prongs of the newly discovered evidence test, he cannot show that his evidence would cause a jury to have reasonable doubt of his guilt. It's a ridiculous thing for the state to say. I mean, I get why they're saying it, but it's still ridiculous. First, the state contends that because Steven Avery did not plead sufficient facts to establish Denny, his allegations would be inadmissible at trial, and thus he is not entitled to an evidentiary hearing on his newly discovered evidence. However, as allegedly argued above, Steven Avery has pled sufficient facts to establish Denny. Therefore, the state's argument fails. Second, it argues that even if the Thomas Sawinski evidence were admitted, and Mr. Avery's theory of defense was presented, there is no reasonable probability of a different result at a new trial. Just ridiculous. Steven Avery has addressed the DNA on the hood latch in regard to Teresa Halbach's bone fragments in his burn pit. The state needs to be reminded that Steven Avery was acquitted of burning Teresa Halbach's bones in his burn pit. Additionally, as noted above, Mr. Avery's current forensic fire expert has completely refuted the state's theory that a human body was ever burned in Steven Avery's burn pit. Steven Avery has explained how Bobby Dassey could be easily responsible for the bullet with Teresa Halbach's DNA being planted in Steven Avery's garage that matched his gun. Teresa Halbach's DNA in the RAV4 and the spent bullets from Steven Avery's rifle in his garage property were easily accessible to Bobby Dassey. As explained above, there are far too many inconsistencies between Steven Avery's allegations about Bobby Dassey and the actual evidence produced at trial. Especially damning would be Steven Avery's complete failure to account for his DNA on the hood latch of the RAV4 and Teresa Halbach's remains, including a fragment from virtually every bone in the human body being found in his burn pit, and nothing to explain how Bobby could possibly be responsible for the bullet with Teresa Halbach's DNA on it being found in his garage and matched to the gun above his bed. The state claims that the enormous amount of forensic evidence pointed directly to Steven Avery as the killer were all far more material than Bobby Dassey. The state misses the mark entirely if Bobby Dassey transforms into a viable third-party suspect because the Thomas Sawinski evidence is found to be credible after an evidentiary hearing. All of the forensic evidence used to convict Steven Avery is now placed in Bobby Dassey's hands. He is no longer facing a jury as a disinterested, unimpeached witness. The state has not presented a shred of evidence that Bobby Dassey did not commit this crime, such as an alibi. In light of his possession of Teresa Halbach's blood-spattered vehicle directly connecting him to her actual murder, his opportunity to plant all of the forensic evidence, and motive established by the pornographic searches on the Dassey computer located in his bedroom. The court that held it's unconstitutional refused to allow a defendant to present a defense simply because the evidence against him is overwhelming. Steven Avery would be able to present his theory all of the evidence against him was planted and that Bobby Dassey is a viable third-party suspect. There is reasonable probability of a different result at a new trial. Absolutely. In addressing a Brady claim, the court is not to view each piece of suppressed evidence in isolation. Instead, the court is required to assess the cumulative impact of the suppressed evidence to determine its viability. Suppressed evidence is material if its cumulative effect creates a reasonable probability of a different result at trial. A reasonable probability of a different result exists if the suppressed information undermines confidence in the verdict. A reasonable probability is lower than the state claims Steven Avery's dogged insistence that Bobby Dassey was the state's primary witness against Steven Avery at trial remains false, no matter how many times he repeats it. Bobby Dassey established only that Teresa Halbach arrived at the Avery salvage yard on the day in question, and that he saw Teresa Halbach walking towards Steven Avery's trailer shortly after she disappeared. Bobby was the state's primary witness against Steven Avery. During his closing argument, prosecutor Ken Kratz once again emphasized the importance of Bobby Dassey's testimony and vouched for his credibility. He also said in his closing statement that one person and one person alone committed the murder of Teresa Halbach, and then a short while later also went to trial against Brendan Dassey to convict him of the murder as well. I don't know. It makes absolutely no sense. We talked more about the timeline and we heard from Bobby Dassey, again in the same kind of position to be, his credibility to be weighed by you, but as an eyewitness. Again, an eyewitness without any bias, individual that deserves to be given a lot of credit because sometime between 2:30 and 2:45 p.m. he sees Teresa Halbach, he sees her taking photographs, he sees her finishing the photo shoot, and he sees her walking towards Uncle Steven's trailer. That's what Ken Kratz said in his closing argument. Bobby Dassey's testimony was the most determinative of Steven Avery's guilt because the state used it to establish that Teresa Halbach never left the Avery property alive. If the jury knew that Bobby was lying about seeing Teresa Halbach leave the Avery property because he was in possession of her blood-spattered vehicle and moved it back into the Avery salvage yard, then the defense could have argued that Bobby Dassey was directly connected to the actual murder of Teresa Halbach and planted the forensic evidence to frame Steven Avery, with a viable third-party Denny suspect who was directly connected to Teresa Halbach's murder and to planting the forensic evidence to convict Steven Avery. Confidence in the verdict would be undermined. There is more than sufficient evidence to conclude that Bobby Dassey actually committed the crime. There is no reason for him to have told the multiple lies he has told in the case if he has no culpability. There is no reason for him to have possession of the victim's blood-spattered vehicle or to have planted it on the Avery property. There is no reason for him to have unexplained scratches on his back or the victim's cut, fuel-stained bones in the Dassey burn barrel. Bobby was the only family member to stay on the property after the others have left. Steven Avery's Brady claim regarding Kevin Romlo has not been litigated. The state incorrectly claims that Brady issue regarding Kevin Romlo seeing the RAV4 was already litigated. In the appellate court's July 2021 opinion, the appellate court noted that Steven Avery's motion for reconsideration, he raised an issue pertaining to a witness affidavit attesting in 2005 a witness, Kevin, observed a vehicle matching a missing persons poster of Teresa Halbach's car and informed law enforcement of the fact that the state withheld evidence that Teresa Halbach's vehicle was seen on the street days after her disappearance. The appellate court declined on the issue and therefore it was never litigated. Specifically, the court stated the following: neither we nor the circuit court have squarely considered whether these claims are procedurally barred under that case I spelled a few minutes ago, or whether Avery pled sufficient material facts entitling him to a hearing. Although our analysis overlaps with the former inquiry, such consideration would have to come in a separately filed Wisconsin statute motion, and we express no opinion as to whether such claims would be barred in the event a motion is filed. Steven Avery could not have discovered the existence of Kevin through reasonable diligence because there was no mention of him in any police report or prior defense counsel's file. It would have been impossible for Steven Avery to discover this evidence. It was only after Steven Avery filed his 2017 motion that the witness came forward. The record does not conclusively demonstrate that Steven Avery could establish a Brady violation at a hearing. The state claims even if Steven Avery's Brady claim regarding Kevin were not previously litigated, it would fail because the record conclusively demonstrates that Kevin says in his affidavit about telling Sergeant Andrew Colburn on November 4th that he saw the victim's RAV4 on a highway cannot possibly be true. The state proceeds to dispute Colburn's schedule, which is an improper attempt to litigate a witness' credibility in the pleadings. Kevin's credibility must be the subject of an evidentiary hearing. Regarding the Sawinski evidence, the state deliberately conflates that the snippet of audio that Steven Avery discovered with the information that Thomas Sawinski provided to police. That is the basis of his Brady claim. Steven Avery does not have to present any audio, including a snippet of audio, to his alleged Brady violation. In fact, the significance of the audio is that it corroborates the fact that Thomas Sawinski provided exculpatory information to the Manitowoc Sheriff's Department that was suppressed by the state. Thomas Sawinski could simply testify he reported his occurrence to law enforcement, and if this court finds him credible, it is sufficient to establish a Brady violation. The state's claim that the audio clip transcripts undermines the veracity of Steven Avery's claim is nonsensical because the court can listen to the audio clip without looking at the translation provided by Steven Avery. The audio clip from Manitowoc's Sheriff's Office speaks for itself. Further, in regard to footnote 10 of the state's response, Steven Avery is not obligated to have an affidavit from Sergeant Senglaub or any investigator at the Manitowoc Sheriff's Office who spoke to Thomas Sawinski on the phone. It is sufficient that Thomas Sawinski would testify that he made the call to the Manitowoc County Sheriff's Office, and it is up to the court to determine his credibility. The audio clip provides some corroboration of Thomas Sawinski's affidavit. Mr. Avery has satisfied the Allen requirements for an evidentiary hearing. The court in Allen 2014 determined that a motion contains sufficient material facts for an evidentiary hearing if it includes the name of the witness, who, the reason the witness is important, why and how, and the facts can be proven, what, when, and where. That clearly satisfied the Bentley standard and would entitle a defendant to a hearing. As with any other civilian pleading, in assessing the legal sufficiency of the motion, the court must assume the facts alleged to be true. Even if a court is disinclined to believe the evidence offered by a movant, the court must hold a hearing before making the credibility determinations. Only after an evidentiary hearing is the court charged with determining the issues and making findings of facts and conclusion of law. Conclusion. Mr. Avery respectfully requests that the court grant him one of the following alternate remedies. Grant an evidentiary hearing, grant his amended motion for post-conviction relief by ordering a new trial, grant requested relief, and grant any and all relief this court deems appropriate. Dated this day, yesterday, January 26, 2023, and then it has the signatures of Kathleen Zellner and Stephen Richards, who are Steven Avery's attorneys. Well, that's the end. 6 parts. That's the whole document. Hopefully, man, it's stacked with a ton of evidence. It would be absolutely insane. I've said this before. If the court denies this, and they've denied it every single time, but there's no way they can look at that and say it doesn't deserve to be looked at the very least. And if it is, it just goes to show once again that the state is scared to go to court because they know Kathleen Zellner will expose them for everything that they've done. Allegedly, of course. Thank you for watching these videos. Let me know what you think of the newest motion by Kathleen Zellner. Leave some comments below. I hope you're having a good day, and I'll see you again soon.